Mr. Vikram Nair.
Mr. Speaker, I rise in support of this bill. The threat of online falsehoods is a real and an insidious threat that subverts the idealistic notions of free speech. As a teenager, I grew up believing in the concept of the marketplace of ideas, where everyone is free to speak, eventually lies would be exposed, and the truth would prevail. On this basis, there's very little need for the government to legislate in relation to free speech. Subsequently, though, the experiences of life, and certainly the study of law, has made it clear to me that this idealistic notion is not supported by real-world problems. Speech is restricted for many different reasons. The laws of almost all countries prevent inciting violence or inducing people to commit crimes. Defamation also results in liability in many countries. Hate speech is also getting more attention, and in Singapore, there have always been laws that prevent people inciting hatred against others. Generally, the law steps in when freedom of speech is abused to cause harm. The latest abuse of free speech is the threat of fake news. Minister Shanmugam has set out in vivid color the nature of this threat in his speech. Falsehoods are deliberately created, for example, by foreign state actors, to interfere with and subvert governments and electoral processes in other countries. The fact the US presidential election and the Brexit vote involved significant amounts of fake news being circulated and relied on by voters shows that even the most advanced democracies are vulnerable to this threat. In parallel, there are many who profit from fake news, and these include those who originated as well as those who helped circulate it, such as social media platforms who make money from advertising revenues. Fake news is often sensational, interesting, and plausible, so it goes viral. The cost to produce it is not so high, as no real research work is needed, and it's easy to circulate. In contrast, serious news providers are suffering because the cost of producing real news is high. You have to pay journalists, opinion writers, the cost of publication, and even airtime. Ironically, after incurring all these costs to produce real news or considered opinions, which is often not sensational because they're presented fairly, they increasingly lose its market share to those that peddle fake news. News providers all over the world are suffering from falling revenues and profitability. Indeed, this is the complete inverse of the marketplace of ideas. The fake news prevails over the truth. Essentially, the truth gets drowned out by falsehoods because it is more expensive to produce, less interesting, and ultimately, there are less people producing it as news providers go out of business. This, in turn, also subverts the democratic process, which works best when people are well informed and able to make decisions based on the facts. Now, it is clear that everyone in this House agrees fake news is a threat. The differences in relation to this bill are, in fact, relatively minor, and it has to do in how to address this threat. Now, my friends from the Workers' Party are with us on the nature of the threat. Their main difference of opinion is that they believe the judiciary should make the decision first and issue directions rather than the executive. Now, what the bill envisions is a competent authority, because fake news is a relatively prevalent problem. Fake news is easy to generate, it's going to be voluminous, and you will need people who will be able to deal with this as and when it comes up. So you'll need people who can make a large number of decisions relatively quickly. And in this sense, it makes perfect sense to leave it to the executive, right, or a competent authority. Now, if someone disagrees with the competent authority's decision, they can take it up to the minister. Now, there are allegations that ministers will abuse power and insinuations that because they're often the party will be used for political purposes. If a minister were to do that, it can be taken up to the judiciary. And the judicial process is a transparent one. The judge will decide one way or the other. The government doesn't always win, so it's a fair process. And it'll be open to public scrutiny. So if there is any abuse of power, there will be public scrutiny on this as well. So in my view, I think it is a fairly sensible mechanism because it allows things to function efficiently while creating avenues for checks and balances. And in government, you need efficiency. Fake news moves fast, it moves quickly. You need an authority to deal with it in a quick way. Now, I was also interested in the variety of tools. A lot of attention has been given to directions and corrective, the directions, which include statements of correction. And of course, this is likely to be the most commonly used tool. But there are also interesting powers that included in the bill, which includes powers against false amplifiers and fake news websites. Can the Minister elaborate on how these powers would be used? There's also an interesting question about what happens to fake news that is already there, already in the public domain. That means news that is not generated in future. Will these laws apply and give the authority powers to deal with that as well? My own view is that it should, because the fake news is out there. Now, let me also, my friends have also made a lot of, the Workers' Party made a lot of allegations about how the judiciary would be impartial and therefore should make the decision, and the judiciary can make the decision quickly. As a practicing lawyer, I have to say the judiciary are under, they have a very huge caseload, and if the executive have to go before a judge for every single decision, which we have to make several a day depending, because fake news is so easy to generate. In a volatile period, you may have hundreds of fake news articles circulating a day. Are you supposed to have hundreds of applications in court with the executive going up against the defendant each time and the judges to decide under the gun? I think that would be a complete abuse of the judicial process, a waste of resources, and ineffective against the threat. So I think it's completely unworkable. But the system of having judicial scrutiny at the end, I think, is actually very effective and very logical, because in a sense, the authority decides first, the minister has a chance of review, and if the minister makes an improper decision, that will be under scrutiny by the judiciary and by the public in that process. So the minister is in fact taking more political risk by doing that, as opposed to leaving it to the judges, in which case the political risk can be abdicated. So in this sense, I think it puts responsibility in the right place for an efficient operation of the mechanism. Now, there's also an amendment filed by some of our friends, the nominated members of parliament, which include a large number of additional checks. And I think, I'm grateful they put so much thought into the process, and some of the points I think are well made, in particular the one about the minister having to make the decision quickly, and I think this is going to be captured in subsidiary legislation. But with the greatest of respect to my friends, I don't think a lot of the other mechanisms are probably necessary, including the setting up of a council, because what you want is a process that operates well and efficiently. It seems to me the work of the council really is to scrutinize how the authorities are exercising their powers and to publish reports on that. I think that can equally well be done by academics or people who have access to the informations. And questions in Parliament can be filed about decisions made by the minister, how many have been made, and so on. So I don't think we need to set up another body by statute to achieve these objectives, and I think many of the objectives for scrutiny and all that can be done through much simpler mechanisms. So with that, Mr. Speaker, I stand in support of the bill. I think it is much needed legislation to deal with the present threat. Thank you.
Mr. Dennis Tan. Mr. Pritam Singh.
Thank you, Mr. Speaker. I'd like to thank the Honourable Member, Mr. Vikram Nair, for his comments. Just to follow up on his point that volume may upset the process, efficiency could be at risk. When we passed POHA just yesterday, this House envisaged the setting up of the Protection from Harassment courts. And one can imagine the remedies that are provided for under POFMA are also available to ordinary Singaporeans, companies in Singapore, thousands of companies. I would imagine that the courts actually would be prepared for this volume of applications that could be made to it, even more so, as we found out yesterday, that the application process would be quite simple. So my point is, would it not be foreseeable that actually the courts could take on that additional task of looking through applications, whether it comes from the individual, a company, or the government?
Well, my view is that it is unnecessary for the court to do so, and especially if you're in a hot situation, say largely elections as happened in the US and in Europe, you have hundreds of articles a day. How are the judges going to come in and make a decision? Is the executive supposed to come in and take out 100 applications and then get the respondents for each one? It's far better if they can just make the decision and get it done. And then if there's a challenge later, that can come up through the judicial process, which is, I think, a more prudent use of judicial resources. I believe the threat of online harassment will not be as prevalent as fake news, because fake news tends to coalesce around certain periods of time, and that's when you need to move fast.
Mr. Leon Pereira.
Thank you, sir. Just an additional point of clarification to the Honourable Member, Mr. Vikram Nair. He mentioned that the process of a judicial review of directives under POFMA would be unworkable because there would be hundreds of cases of fake news every day. Is the Honourable Member suggesting that the powers under POFMA are likely to be exercised? Does the Honourable Member envisage that these powers are likely to be exercised several hundred times every day? Thank you.
It may have to be depending on the volume of attack we come under, but certainly I think in the elections in Europe and the US during those periods, there was very large amounts of fake news.